Hello, my name is Aditya Singh and I am the Director of CLAT Essentials Kolkata Ruby as well as the next student of the Hidayatullah National Law University. Today we will be talking about an important GK topic for your CLAT exam. The topic is called same-sex marriage in India. So I'll be dividing the topics accordingly as per the things which we need to cover. We'll be starting from the background, we'll be discussing important timelines, and we'll also be discussing some important trivia as well as the present scenario. Okay, so let us begin. So coming to the background of same-sex marriages in India, you must be knowing that same-sex marriages as well as civil unions are not allowed in India. Okay, now there are two very important cases when we talk about same-sex marriages in India. The first case is KS Puttaswamy versus Union of India. The judgment was given in the year 2017. In this year, in this very particular judgment, the right to privacy became a fundamental right under Article 21. Article 21 basically means that it ensures the right of life and personal liberty. So it becomes very important that when privacy was guaranteed to an individual, it was necessary that other things also come under the purview of privacy. One of them is homosexuality. So similarly, in the year 2018, what happened was another judgment was passed by the Supreme Court of India. It is known as Navtej Singh Johar versus Union of India. In this judgment, basically the Supreme Court of India, it was a very landmark and important judgment because homosexuality was decriminalized through this judgment. So it becomes very important for you to know these two judgments before moving ahead. The third judgment which comes to mind, it is known as Deepika Singh versus Central Administrative Tribunal. This judgment was given as recent as August 2022. In this judgment, basically certain rights and benefits of same-sex couples who are living in live-in relationships was recognized. So even though marriage is not recognized, it allows same-sex couples to cohabit in live-in relationships as well as enjoy the perks which come with live-in relationships. Now, as an Indian, as a person residing in this country, the question which comes to your mind is that everybody looks down on homosexuality, absolutely, but people also look down on live-in relationships in our country. Even though they are prospering now, as arranged marriages are declining, living relationships are increasing in number, but still living relationship is something which is not looked at in a good light by a lot of people, mostly people from the orthodox as well as the conservative mindset. So now I'll tell you, even though that is happening, there are certain significant changes which have happened in the law, starting with CRPC, the Criminal Procedure Code. In the Criminal Procedure Code, basically previously the term wife was used explicitly, but now the term has been replaced with live-in relationships, and it has been expanded to live-in relationships. So you need not necessarily be a married person to get the benefit under CRPC. Apart from that, there is another act which is known as the Protection of Women from Domestic Violence Act 2005. In this act also, previously all the benefits they were given to a married spouse or a married person, a married wife. Okay, but now again it has added another sentence. This sentence is known as relationship in the nature of marriage. So basically it is now expanding itself not just to marriages as well as to those relationships which are of the nature of marriage, which essentially means live-in relationships. So you can understand the law, it has expanded itself, and now if you are getting rights in a live-in relationships, that is also a very win-win situation. So that has been provided to the homosexual couples even though they don't have marriage. So it's very important for you to know about that. Okay, we'll be talking about some of the decisions which happened at the regional level before coming to other things of the present scenario, because this Deepika decision which was given, it was built on the basis of other decisions which had happened in the past in certain regional courts. Okay, so the first court to give a decision in this regard, it was the Uttarakhand High Court. It gave a decision in June 2020 wherein live-in relationships and same-sex couples in live-in relationships, they were giving certain benefits under Article 21, whereas another judgment was passed just 1 month prior to that by the Odisha High Court. The Odisha High Court in that said that same-sex couples who are living in live-in relationships, they were given benefits as per not just Article 21 but also Article 14. Now I'm sure you know what Article 14 is. Article 14 basically means right to equality. So everybody should be having equal protection as well as equal rights in the eyes of the law. So that is what it says. So that is something which was also argued by the Odisha High Court, and rights were given. So these two judgments become very important in the build up to the judgment of the Deepika versus the Central Administrative Tribunal, where homosexual couples were given certain rights when they were in live-in relationships. Okay, now there are certain customs which I'll talk about. There are two customs in particular which I read about, which I came through my research. So I'll tell you about both the customs. The first custom is the Matri Karar. Okay, so the Matri Karar basically means a friendship agreement. So this was first seen in Gujarat. Okay, and this is basically in the nature of giving rights to people who are of the same gender. Okay, so essentially they are not forming a marriage, but they are forming a friendship agreement in which they are getting certain rights and have certain responsibilities. There was another form which was known as Nata Parthi, which is basically prevalent in Rajasthan and Madhya Pradesh. So if you know the name, that's very much enough. I don't think you need to get into the details of this. Okay. Thirdly, now I'll talk about the present scenario. So how this same-sex bill, or how initiative has been taken by the courts to legalize same-sex marriage in India. So this was started when a private member's bill was introduced by a member of parliament. Her name is Supriya Sule, and she is a member of the Nationalist Congress Party, or the NCP. Okay, and she basically asked the legalization of same-sex marriage under the Special Marriage Act of 1954. So you must be knowing one thing with regard to marriages in India. The problem with marriages in India is that there are different communities in India. There are Muslims, there are Hindus, there are Sikhs, there are Christians. So everybody has their own religious codes, okay, and they have their specific statutes. So everybody marries as per their religion, as per their beliefs. So that is why it becomes very difficult when you are trying to make marriages uniform. In case of same-sex marriages, if you try to bring a uniform law, they have to make sure that everybody, irrespective of the fact whether they are a Christian, whether they are a Hindu, they are enjoying the benefits. So it is becoming complicated because there are a variety of legislations. Okay, so I'll note down all the legislations for you, because it becomes very important for you to know the name of the 6 major legislations which are talking about marriage rights in India. Okay, so the first legislation is the Hindu Marriage Act 1955. Okay, the second legislation is the Special Marriage Act 1954, which basically allows people from different communities to marry. Okay, apart from that, there are other acts also, like the Indian Christian Marriage Act 1872, the Indian Christian Marriage Act 1872. There is the Shariat of 1937. Okay, there is the Parsi Marriage and Divorce Act of 1936. And then there is the Anand Marriage. So after the Parsi Marriage Act of 1936, there is also the Anand Marriage Act of 1909. So you can understand Anand Marriage Act is for Punjabis, and rest of the marriage acts, they clearly tell you which community they belong to. Shariat is for Islam. Okay, so I think you are clear with this. Once you know all these marriage acts, you will understand why it's becoming difficult to bring same-sex marriage into India. Okay, because see, marriage is a union wherein you don't just get married and everything is done. There are certain rights which accrue after marriage also. There are rights with respect to divorce. There are rights with respect to maintenance. There are succession rights also. So every community has its own different set of rules. So unless and until there is a uniform structure, or there is a uniform civil code which is given in Article 44 of India, so unless and until we have that same uniform law everywhere, it becomes very difficult to implement the same-sex marriage in India. Okay, that is why it's still on hold. Okay, now next we'll be talking about some other things. The Uniform Civil Code, like I told you, presently it is only applicable in the state of Goa. Okay, and apart from that, it is also applicable in the Union Territories of Dadar and Nagar Haveli, as well as Daman and Diu. So you can remember, these are the places where same-sex marriage will be easier to build. It will be easier to bring about same-sex marriages in these places as compared to the rest of India, because of the presence of the Uniform Civil Code. Okay, now next we will be talking about the timeline of how this same-sex marriage phenomena, or how this entire case came into being. So after the private member bill was passed, certain petitions were also filed in the high courts. Okay, so we will be talking about each of these petitions one by one. I'll just be telling you all the relevant details which you need, because see, one thing you need to clearly understand with respect to prep, not just in your CLAT exam, but also preparation in your bank exam or any other exam for that matter where you have current affairs, you need to understand the fact that in current affairs they can only ask you questions which are based on facts. Okay, so you need to take out facts, you need to study them, you need to make your notes based on facts. Opinions don't matter, any other such thing which has a lot of subjective knowledge does not matter. So I only make my notes with respect to facts, and that is what I try to give you in these videos also. Okay, so there were three main petitions which you find in the Delhi High Court. I'll tell you the name of each of those petitions. The first petition is known as Abhijit Iyer Mitra and others versus Union of India. Okay, in this basically a right for marriage for same-sex couples was asked under the Hindu Marriage Act, and the reason why this was asked was because Section 5 of the Hindu Marriage Act says that marriage is a union between two Hindus, but it never says that marriage is a union between a man and a woman. Okay, so that is why the main argument here was that if the act no way says that same-sex marriage cannot be allowed, so their argument was that you should expand the purview in such a way that same-sex marriages can be allowed under Section 5 of the Hindu Marriage Act. Okay, next the second case was Dr. Kavita Arora and another versus Union of India. In this basically they asked for the legalization of same-sex marriage through the Special Marriage Act of 1954. Okay, and the last case was Vaibhav Jain and another versus Union of India. In this, basically the situation was that there was an overseas citizen of India, so it was involving a person who is residing somewhere else presently. So he was asking for recognition of the same-sex marriage under the Foreign Marriage Act of 1969. So these were the three main statutes which were invoked in their petitions. Okay, so you can understand that. Next. Now, the first hearing was held on 8 January 2021, and the judges behind this hearing, they were Justice Rajiv Sahai and Law and Sanjeev Narula. Okay, and they gave one last chance to the union government, because what was happening was these petitions they were getting filed, things were happening, but the only problem was union government was not responding. They were not saying anything about this. So they gave them a last chance. They said that if you don't respond to these petitions, we'll have to take a ex parte decision. Basically, ex parte means by hearing only one side. And this can happen when one side is unable to represent itself after repeatedly calling them to the court. Then ex parte decisions can be given. Okay, so that is something the court said. And thereafter the government responded. The government appointed its own lawyer, and his name was basically, he was called Tushar Mehta. He is also the Solicitor General of India. Now, the Solicitor General is a major law office which you should be knowing since you are studying for your CLAT exam. And you should also be knowing that the Solicitor General of India, he is appointed under Article 76 of the Indian Constitution. So you can remember that as well. Okay, now next. Basically, after this happened was there was a fourth petition again filed after this. So after these three petitions, another fourth petition was filed. This fourth petition was filed in May 2021, and this petition was basically so this petition was basically, after this petition got filed, the union government had got enraged because it was the month of May in 2021. So basically they said that there are a lot of issues which require national importance as of now, because we were dealing with a pandemic back then. The coronavirus was hitting us really badly. So they were like, we should first solve the corona issue, after which we'll talk about this thing. So it got delayed for a while after that, okay, and the things were halted. But in the meantime, what happened was, in total 9 petitions were filed, and they were filed mostly in the Delhi High Court as well as the Kerala High Court. And that is when the Supreme Court thought, okay, now I think it's enough. A lot of petitions are getting filed. Now they will themselves take control of this case. And that is when the Supreme Court said that all these cases, all these petitions, they need to be clubbed together and they need to be sent to the Supreme Court of India, which will now hear this case. Okay, so the Supreme Court of India agreed to hear this case in November 2022, and the first hearing it happened in January 2023, which is this very year itself, which is why it becomes even more important for your CLAT exam, because this has happened after the last CLAT. So you can understand that something happening between the last CLAT and the upcoming CLAT, that becomes very important. And this issue, which is related to law as well as India, is quite important actually. Okay, so the first hearing, it was held on 6 January 2023, and in this hearing petitions were transferred, and this was asked by the Chief Justice of India, D.Y. Chandrachud. Now that I am telling you about D.Y. Chandrachud, you should remember one thing. D.Y. Chandrachud is the son of Y.V. Chandrachud, who was also a famous Chief Justice of India. And the reason why he becomes very famous, this is something I'll ask you. you need to tell me why YV Chandrachud is important. There is something very unique about YV Chandrachud, something which, some record which he holds. So if you can tell me in the comments as to what record he holds, that will be really good. I'll definitely respond to them. Okay, so you can tell me in the comments what record is held by YV Chandrachud, who was the father of DY Chandrachud, the present Chief Justice of India. Okay, now basically Article 145 subpart 3 was invoked by the Supreme Court of India, and this Article 145 subpart 3 basically says that whenever there is a question of which is involving the interpretation of the constitution, okay, so in those cases there should be a 5-member bench, there should be a 5-member judge bench which should decide the case, so that there is no arbitrary decision as well as a biased decision, because everybody can have, every judge can have their own viewpoints. Okay, so in order to neutralize any sort of conflict, it is always needed that there are more judges on the bench. So that is why a 5-judge bench was formed. Okay, so I'll tell you the name of the 5 judges who were involved in this 5-judge bench. Okay, so the first judge was the Chief Justice of India, his name is DY Chandrachud. The next judge was SK Kaul. Then we had SR Bhatt. Then we have Hima Kohli, and lastly we have PS Narasimha. So these were the 5 judges who were involved in this entire scenario. Okay, and apart from that, there were also 5 advocates who, there were also 9 or more advocates who were representing the petitioner's side. I'll tell you name of some of the important advocates, because it's not possible to tell you the name of all the advocates. Okay, but if you know the major ones, that will do. Okay, so Mukul Rohatgi, he previously held a constitution post in India also. You can tell me which post was held by Mukul Rohatgi. Okay, so he was there. Apart from that, Menaka Guruswamy was also there. She is also an eminent lawyer. Apart from that, they had Saurav Kirpal, who is openly gay. He's an openly gay lawyer. Okay, so that is why he becomes important. And there were several others also, whom if you want, you can research and write it down in your notes. Okay, now the main contention as to why the Indian government was saying that we are not ready to do this, we are not ready to legalize same-sex marriages. Firstly, they were saying that India is a place where there is a lot of culture, there is a lot of old traditions which are followed in India. So basically they were saying that this concept of same-sex marriages, it has never been seen previously in India, and this is something which is not endorsed by the Indian culture. So they were like, we are not with it. The second thing, like I told you, because of the multitude of different personal laws which are there in India for every community, they were like, even if this was something which was told by the Supreme Court itself, that even if they bring in the marriage law for same-sex couples, it will be very difficult to understand. As to some statutes, they say between a husband and wife. These words are mentioned in a lot of statutes. So how will we determine who is the husband, who is the wife? How will succession, maintenance, these things be given? So there are certain problems which will need to be resolved first in order to basically allow same-sex marriages in India. Okay, and one very important thing which was said apart from this was said by the Parliament of India. It was said that in this entire matter about marriage, it concerns the society, not just the individual. Okay, so whenever something concerns the society, it becomes very important that the society which is being concerned, that will have to be addressed, that will have to be heard of, then only a decision can be taken. So it was said that the people in the parliament, they are basically representatives of the society. So this matter is a matter to be decided by the parliament and not the Supreme Court. This is what the parliament said, but it has been directly rejected by D.Y. Chandrachud. So basically the court will give a decision on this regard. They might not allow marriage, but they will definitely do something which will be in the forward direction. Okay, now the verdict of the Supreme Court, like I told you, as of now the verdict is not out. The verdict is reserved by the Supreme Court of India. So you can understand the verdict will be given in the days to come, but as of now we don't have any verdict. So this case becomes even more important, because I think in the coming months we'll get a verdict. So as soon as we get a verdict from the Supreme Court of India, we can decide as to what is going to happen in this regard. Okay, so as of now, you can continue your notes till this point, and we have to wait for the verdict of the Supreme Court of India as well. Okay, now I'll tell you certain related trivia. Okay, now we come to the last part of this discussion. Okay, so the last part of this discussion, since it's a GK discussion, you should always remember that facts are the most important thing, like I told you. So I have told you the background, I have told you the entire story, the trials, everything, the name of the judges. So now what becomes very important after you have done this is that you should also refer to the trivia related to this topic. If you don't know the trivia, that is something which usually gets asked the most. So you need to remember trivia is absolutely important and you can't miss it out. So I'll read my questions which I have prepared in the trivia and I'll tell you the answers as well. But I'll suggest that if you find something else which might also be important to the topic, you must add that to your notes, because I think there'll be a second part of this same-sex marriage video also, which will come when the verdict comes out. So back when the second part comes out, I'll add anything which I have missed this time. Okay. So the trivia part now. So first and most important thing, which is the first country to legalize same-sex marriage? Okay. So the first country to legalize same-sex marriage, that is Netherlands in 2001. Okay. Now, second question. What was the first same-sex couple in the world? Okay, their name also becomes extremely important. Okay, so the first same-sex couple in the world, their name is Michael McConnell and Jack Baker. Okay, Michael McConnell and Jack Baker. They were people from the United States of America, and they had married in 1971. Okay, now latest, now the most important thing, now that you know the first, you should also know the last country which has legalized same-sex marriage. So the last country to legalize same-sex marriage, as of now, as of May 2023, that is Andorra. Okay, so you should remember that as well. Okay, now the first country in Asia to legalize same-sex marriage, that is basically Taiwan in 2019. Okay, so you should remember that too. Okay, now apart from that, the first country to legalize same-sex marriage through a referendum. A referendum is a situation in which the people are asked that what do you want, and the people vote for the two sides, yes or no, whatever they want, and accordingly the decision is taken. So the people of Ireland were given this opportunity and they sided with same-sex marriage. They were for same-sex marriage, and same-sex marriage was legalized in Ireland in 2015 after this referendum. Okay, now the first country to offer civil unions to same-sex couples. So now, like I told you, in India also, live-in relationships are being provided. Similarly, civil unions are also of similar nature only. They don't give you a marriage as such, but they give you certain rights. Okay, so civil unions were first recognized in Denmark. Okay, and they were recognized in 1989. Okay, and the last thing, and the last question from trivia which I have, after which we are done with this topic, the first country to legalize same-sex marriage through a court ruling, in which the court decided that same-sex marriage will be legalized in the country, that was South Africa. South Africa is also the first country in Africa to legalize same-sex marriage. Okay, and the same had happened in the year 2005. Okay, so you can remember all these important things. If you think you have any other important relatable questions, you can put them on the comments so that I can have a look at them and I can answer them as well. Okay, so that is it from my end, guys. This is all about same-sex marriages in India. If you like the video, you can just comment so that we get motivated and we make more videos for you. And I'll try to make more. I'll try to add more value to your GK prep so that you can improve in your prep and you can ensure that GK is the section which doesn't trouble the aspirants this time at least. Thank you, guys. That's it from my end. Bye. See you in the next video.